So how exactly did the Post Office decide, and the Post Office investigation team decide, when to bring forward a criminal or non-criminal case? We'll take a close look at the policy and what Robert Daly has to say with the process that he followed in the prosecutions that was involved in. Let's jump to the inquiry now.
I'd like to turn, please, to the decision-making process for criminal investigation and prosecution of subpostmasters, their assistants and managers, and Post Office employed branch staff in England and Wales on the one hand, and Scotland on the other. Could we have on screen, please, paragraph 136 of Mr. Daly's first witness statement? That is page 36 of WITN 089-40100. And at paragraph 136, you say this: the conduct of investigations in Scotland was similar to England and Wales. The key difference was in the prosecution of cases. As I have described elsewhere in this statement, the prosecuting authority in Scotland is the COPFS, that's the Crown Office Procurator Fiscal Service.
So it sounds like actually in Scotland they have a much more robust case, because you can't just launch a private prosecution without it going through what sounds like the equivalent of the Crown Prosecution Service, which seems to be more robust than the process in England, where anyone can launch a private prosecution. However, obviously there were prosecutions of innocent subpostmasters in Scotland as well, so it didn't seem to totally negate the risk in this case.
Is that right?
That's correct.
All cases, whether they be police or non-police cases, have to be submitted to the COPFS, who then decide whether to proceed to prosecution or not. In around 2006, it became a requirement that non-police authorities had to report cases through the COPFS Specialist Reporting Agency.
So that's the SRA they're referring to. So just to avoid any confusion, it isn't the Solicitors Regulation Authority. They would talk about the Specialist Reporting Agency, which is Scotland specific here.
Website. On inputting a case, you had to input a charge to proceed to submission. So that's the date that you addressed in correcting your second statement at the outset.
That's correct, yeah.
So you believe that that date is in fact correct?
Yes.
So it sounds like he stated 2006, then issued the second statement correcting it to 2010, but now would like to go back to 2006 after disclosure of evidence at the inquiry.
In relation to how cases were submitted to the Crown Office and Procurator Fiscal Service, before the change in 2006, how did that happen?
It was a manual report. You had to do a typed report that was similar to the offender report that was then delivered to the Procurator Fiscal either by post or by hand.
You deal with the process followed by Post Office investigators for criminal investigations at paragraph 59 of your first statement.
Now this will be interesting. How did the Post Office decide to launch the prosecutions? What process did they go through when they prosecuted what we now know to be innocent subpostmasters? Was it robust enough?
Could we have that on screen, please? It's page 17. And at paragraph 59, you say that you have considered 3 versions of the conduct of criminal investigations policy from 2013, 2014, and 2018. You refer to a flowchart from the first 2 of those versions, and you use that to explain the process how the process worked in England and Wales and in Scotland.
Yes.
Could we have on screen, alongside Mr. Daly's statement, if that's possible at all, POL 000310005.
So this is the actual policy here, so effective from 2013, so it's one of the later versions. It'll be interesting to see what's contained in here.
You can see that this is the August 2013 version of the Post Office Conduct of Criminal Investigations policy. Going to the bottom of page 2, please, we see the start of the flowchart you refer to in your statement. It provides, on the left-hand side, a number of sources of a case being raised, including an audit shortage, the Grapevine team. Can you help with which team that was?
The Grapevine team, they were our alarm receiving centre, but to start with, and dealt with any suspicious incidents at post offices. Post offices were encouraged to phone them up so we could send out a text blast. In regards to information, in regards to inquiries, I can't recall what they would have provided to us.
I'm guessing that a grapevine team, it's almost like a tip-off line. So ring us up if you've got any suspicions. I'm guessing it was open to everybody, but obviously would mainly be used by the agencies. Obviously, many of the subpostmaster cases we've heard have been following audits. So the audit shortage is probably the primary route, I would imagine, for the launch of many of these prosecutions.
Also listed as a source are contract managers and client, e.g. DVLA, DWP.
So that's how a case is raised initially. So we're before prosecution here, but a case is raised from those various sources, the primary one appearing to be, and possibly why it appears at the top, audit shortage, as in horizon audit shortages, as in shortfalls.
Going over the page, please, to page 3 of this document.
So we can see there, case assigned to security manager. So security manager is what Robert Daly said his role was at this time in 2013. I think he said he first got a temporary position in 2009. It wasn't made permanent, but then his subsequent temporary position that he applied for was. So that would be him in this case, presumably. Is there evidence to proceed? So he would have to make a judgment call on that. If there was, interview and compile evidence and then prepare for a case. If he didn't think, in his opinion, that there was evidence to proceed, he could put NFA against it. No further action, the case would be closed. Let's see what happened.
Looking down the stage, we can see a number of steps on the flowchart for process. Case assigned to security manager. Is there evidence to proceed? If the answer is no, then no further action, case to be closed. If yes, interview and compile evidence. The next step is case preparation, phase 1 MG format.
So they put that in, then they get a team leader to review the case, proceed with the case. If they decide, it goes to the criminal law team. If they still preside, Cartwright King to produce charges. Presumably that's their legal team. Yes, head of security. At all stages, if they're not sure with that, it leads to further inquiries. If they need further action, if it's a no, then it's NFA'd. Seems like a fairly standard process, which should be robust, going through so many hands, you'd think.
The next stage is team leader to review the case file, proceed with the case, ? If it's no, then it's case closure. Further action could be further inquiries to be made, file returned to team leader. If it is yes, then it goes to the criminal law team to review the case file. Proceed with case, ? No, then it's no further action. Further action required. There could be further inquiries made, file returned to the criminal law team and team leader informed. If yes, then it goes on to Cartwright King to produce the charges.
So there are so many stages in this, so many times to pick up if something doesn't seem right. And yet they seem to have been missed in virtually, well, all the cases that we're hearing about, which is shocking in and of itself.
Is it your evidence that the process in place up to the point of the criminal law team, so stopping short of going to Cartwright King?
So that would be when he handed it over, presumably when it went to the criminal law team as a security manager.
That was essentially the same for Scotland as it was for England and Wales, until the introduction of a firm of Scottish solicitors into the process for Scotland in 2013.
Yes.
In a Scottish case, before this change, so before the introduction of a Scottish firm of solicitors, you say that a decision was returned to you by the criminal law team. So this is in paragraph 59 of your statement, we see alongside. If the decision was to proceed with prosecution, you would submit the file to the Crown Office and Procurator Fiscal Service, is that right?
That's correct.
If the decision was not to proceed, then the case would be closed.
That's correct.
Wonder if the stats on that would be interesting. I wonder how many of these cases got dropped versus how many were actually prosecuted. I think that'd be a really interesting thing to be disclosed.
This document shows the process in place in 2013, up to the point of the flowchart where there is consideration of a case by the criminal law team and not beyond that. Was the process any different from 2005 to 2013?
With the exception of Cartwright King being involved later on. I don't know when Cartwright King became involved, but yeah, essentially
stopping
yes.
short of Cartwright King and stopping at the stage of it being referred to the criminal law team,
yes.
And a decision being made by them as to proceeding. Was the process we've looked at in this flowchart the same between 2005 and 2013, or did it differ in any material way?
From what I recall, it was the same.
Seems to be a bit of a diversion to their answering the question which wasn't asked, and then the kind of I don't recall. I think I recall it's correct. It's a bit non-committal.